The Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, please take the stand. Please take the stand. Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, the charges against you as received from the County Assembly of Isiolo are as follows, and I quote: Ground 1, gross violation of the Constitution and other laws. 1. The Governor has grossly violated Section 30, subsection 2, paragraph K of the County Governments Act by failing to deliver an annual State of the County address for the 3 years that he has been in office. 2. The Governor has grossly violated Articles 201, paragraph D and paragraph E of the Constitution by employing a bloated workforce, including 36 advisors in the office of the Governor, 31 chief officers, yet the county has only 6 departments, and 2 deputy county secretaries whose positions are not known to law. This has created an excessive wage bill that is 46% of the annual revenue allocation, far beyond the 35% limit set by Section 25, subsection 1, paragraph A and paragraph B of the Public Finance Management County Governments Regulations 2015. 3. The Governor has grossly violated Articles 10, paragraph 2, 73, Article 232, and Article 235 of the Constitution, and Sections 59, 59A, 60, and 62 of the County Governments Act 2012 by disregarding the criteria for the establishment of offices within the county public service, by illegally creating offices for advisors and deputy county secretaries without the involvement of the County Public Service Board. 4. The Governor has grossly violated Articles 10, Clause 2, Article 185, and Article 201 of the Constitution by refusing to implement the recommendations and/or resolutions of the County Assembly requiring the Governor to control and manage the county public debt in a manner that undermines the authority of the County Assembly, thus resulting in unmitigated accrual of debt to unmanageable levels. 5. The Governor has grossly violated Articles 201, paragraph D and paragraph E of the Constitution by failing to utilize bursary funds in accordance with the approved budget, resulting in a discrepancy of Kenya shillings 30 million, which cannot be accounted for. Ground 2, abuse of office. That the Governor has engaged in acts and omissions which singularly and collectively amount to abuse of office and gross violation of, among others, Article 201 and Article 232 of the Constitution, Sections 8, 9, 10, 11, 12, and 13(1) and 35 of the Leadership and Integrity Act 2012 by the following: A. Appointing 36 advisors in the office of the Governor, contrary to the Salaries and Remuneration Commission Circular dated 29th July 2013, the Transition Authority Circular dated 6th September 2013, and subsequent guidelines from the Intergovernmental Relations Technical Committee, all of which limit the maximum of advisors to 3. B. Appointing 31 chief officers instead of 18, which are provided for in the County Executive Staff Establishment of July 2022, yet the county has only 6 departments. C. Appointing chief officers under 2-year contracts, thus creating a climate of fear and uncertainty, which reduces public servants to be servants of the Governor and not the people, contrary to Article 73, Clause 1B of the Constitution. The governor failed to renew the contracts of 31 chief officers and instead directed them to hand over to county executive committee members, significantly affecting the continuity of service delivery in the county. And D, appointing 2 deputy county secretaries, which positions are not known to law and are not in the county staff establishment. Ground 3, gross misconduct. The governor has grossly violated 1. Articles 10, Clause 2, Article 27, Article 28, Article 73, Article 75, and Article 232 of the Constitution, and 2. Sections 3, 7, 8, 9, 11, 34, and 52 of the Leadership and Integrity Act. 3. Sections 9, 10, and 21, subsection 2 of the Public Officer Ethics Act 2003. 4. Sections 2, Section 30, subsection 2, and Section 30, subsection 3 of the County Governments Act, by engaging in acts which singularly and collectively amount to gross misconduct by the following: A. Making disrespectful, sexist, and demeaning statements against Senator Fatuma Adan Dulo publicly that are only meant to denigrate and degrade her as a woman leader, thus violating her right to dignity. The governor's utterances do not demonstrate respect for the people and other public officers, nor do they bring honor, dignity, or maintain public confidence in the office he holds. The governor's statements amount to gender-based psychological violence and undermine the dignity and the integrity of the governor's office. B. Breaching public trust by making divisive, derogative, and discriminatory remarks against other clans residing in the county, thus undermining public confidence in the integrity of his office and sowing discord in the community. And C. Being continuously absent from the county and running its affairs remotely from Nairobi, thus stalling service delivery. Honorable Abdi Ibrahim Hassan, how do you plead to the 3 grounds? Ground 1, guilty or not guilty?
I plead not guilty.
Ground 2, guilty or not guilty?
I plead not guilty.
Ground 3, guilty or not guilty?
I plead not guilty.
Next order, clerk.
Order number 3, hearing and determination on the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County.
Now, honorable senators and the parties to these impeachment proceedings, before we embark on the main hearing, Rules 14 of the Rules of Procedure demands that if there are any preliminary issues be raised at this juncture. So if there is any party that has any preliminary issue, this is the moment to raise it.
The Honorable Speaker and the Honorable members of the Senate, we had given an indication to the Honorable Senate that we intend to raise two preliminary issues for the consideration of the Senate, and the issue, Honorable Speaker, is contained in Volume 1 of the document that we filed. In response, we filed several documents, but Volume 1 contains the preliminary issue that we intend to raise. Honorable Speaker, with your leave, I can then quickly delve into that question. The Honorable Speaker, we had noted from the order of proceedings that was supplied by the Senate that this session would take about 1 hour. I propose 2 hours, with 1 hour on our side. I propose to take about 30 minutes or less introducing the first limb of the preliminary issue we intend to raise. Thereafter, my colleague Elisha Ongoya will take 20 minutes, and I will reserve 10 minutes for any rejoinders which will be handled by our colleague, Mr. Elias Mutuma. Mr. Speaker, sir, and honorable members of the Senate, with your permission, we would then move to raise the preliminary question.
So what you're saying is you require 1 hour to effectively move your preliminary issue?
Yes, Mr. Speaker, sir.
Okay. I'll grant you 1 hour, and also I'll grant the County Assembly 1 hour to respond to your preliminary issues. You may proceed, and time starts running from now.
Thank you, Mr. Speaker, sir. The Honorable Speaker and honorable members of the Senate, on the 26th of June 2025, the Speaker of the Isiolo County Assembly issued a press communication at around 3 p.m. announcing that the County Assembly had resolved to impeach the Honorable Abdi Ibrahim Hassan, Governor of the Isiolo County. This communication will be found in Bundle 3 of our volume, that is Volume 3, at pages 2, 3, 4, and 5. This release is significant in these proceedings as it marks, in our view, the announcement of a phantom impeachment of the governor, and we will shortly demonstrate the salient gaps and schemes, and hopefully persuade the Senate to reject this phantom impeachment. The Honorable Speaker and honorable senators, the press release by the Speaker of the Isiolo County Government triggers a very important question, and that is the question upon which our first limb of the preliminary objection stands. What is in law a resolution of the County Assembly? The Isiolo County Assembly Standing Orders, and specifically Standing Order 65-8, provides that when a motion for the removal of the governor is passed by at least 2/3 of all the members of the Assembly, the Speaker shall inform the Speaker of the Senate of that resolution within 2 days. You will find this resolution from the Assembly in the Assembly's volume, that is volume 3, at pages 100. So, Honorable Speaker and Honorable Members of the Senate, it is our submission that for the power of the Senate to be invoked under Standing Order 80, the Speaker of the Senate must receive a resolution from the Speaker of the County of Assembly. So therefore, there is a test that is twofold. The first test is that there is a resolution, and the next is that it is supported by 2/3 of the members of the Assembly. Honorable Speaker and honorable members of the Senate, in forwarding this resolution, the Senate standing orders, the third schedule of the standing orders, and the Senate's guide manual on the procedure and rules for removal of county governments developed in 2025 require certain documents to be submitted together with the resolution. And that is the impeachment motion, the county assembly Hansard, the division of voters list, the advertisement of the summons to the governor, the list of witnesses of advocates, the list of advocates, list of witnesses, records and videos, and other evidence. It is our submission that this has a very good purpose. This requirement has a good purpose, and it now fits into the preliminary objection that, or the preliminary issue that we raised. Honorable Speaker and the honorable senators, I will then invite you to examine the documents that were presented alongside the resolution from the Speaker of the Isiolo County Assembly in support of the fact that there was a resolution adopted by the Assembly to remove the governor. I will refer the Senate to the Assembly documents, and that is at volume 3 of the Assembly documents, that pages 1 to 6, which has the order paper for the 18th, and that order paper ultimately indicates that the motion for the removal of the governor was adjourned to Thursday, the 26th of June 2025 at 2:30. That time is extremely material to these proceedings. The Hansard for the 18th of June 2025 at pages 7 to 14, that is still volume 3 of the Assembly documents, indicates that the proceedings for removal of the governor were also adjourned to 26th of June 2025 at 2:30. At pages 15 and 16, that is still of volume 3, there is an invitation to the governor to attend. That invitation invites the governor to attend the Assembly on the 26th at 9 a.m. Honorable Speaker, volume 5 of the Assembly's documents at pages 3 and 4 contains the affidavit of service of that invitation served by the Speaker. So there is no doubt whatsoever that the governor is invited to appear at 9 a.m. on the 26th. The Speaker in volume 5 also presents a document for the special sitting of the Assembly. It is dated 23rd of June 2025, and that sitting is indicated to commence at 9 a.m. Honorable Speakers and Honorable Senators, it is therefore not in any doubt that the Assembly set the hearing of the motion for at 9 a.m. 26th of June. I now refer the Honorable Senate to the Isiolo standing orders. Standing order, specifically standing order number 1, it is found at volume 3, pages 85 and 86, on the times set for the sitting of the Assembly, and that is 9 a.m. for Wednesdays and 2:30 for Tuesdays, Wednesdays, and Thursdays. I do not need to say this because you're familiar with these times. It therefore follows that if the Assembly is to meet at any other time other than as set out in the standing orders, there must be a resolution to that effect. And so, therefore, the logical question that we are asking the Senate is this: is the Hansard genuine? Because the Hansard talks about a sitting conducted at 2:30 p.m. That is in line with the standing orders. But the notices, the invitation, and the special sitting issued by the Speaker talk about a sitting to be conducted at 9 a.m. So therefore, Honorable Speaker and Honorable Senators, we invite you, the Senate, to take note of the above, and then allow us to also review the Hansard that is provided. You probably understand the Hansard much better than we do, and I refer you to the Hansard for the 18th of June 2025, which clearly shows that the Assembly was adjourned to 26th of June at 2:30 p.m., and I refer you to volume 3 still of the Assembly's documentation. The issues that you will note when you review the answer is that, first of all, it is not certified by the clerk as is required. It just bears a stamp. It is therefore our submission that these latent, open, obvious, and blatant contradictions and anomalies between the Hansard and other records provided by the Assembly are major indicators not only of misrepresentation, but that the documents presented by the Assembly have been cooked and generated outside of the Assembly. This is further supported by the testimonies of the witnesses, which will be found at volume 2 of the Governor's response at page 14, where we have the affidavit of Salad Boru Gurasha, who was the clerk of the Assembly, who confirms that there was no sitting of the Assembly on either date. There is an affidavit by the Leader of Majority, Diba Ali, at pages 41 to pages 45, who confirms there was no sitting of the House Business Committee to deliberate and set out the order papers. Further, we have the affidavit of Shaban Mzungu, who was in charge of security at the Assembly on that particular day, and he confirms that there was no sitting of the Assembly. Honorable Speakers and Honorable Senators, we expect that the Assembly will try to persuade you that the issues we raise are not preliminary and they require a full evidential hearing. But allow me, Honorable Speaker and Honorable Members of the Senate, to refer you to the Assembly's submissions on the preliminary objection, because they have filed submissions on the preliminary objection and they have quoted a decision. And the jurisprudence from the courts is that a preliminary question is determined on the presumption that the facts pleaded are true. The facts that we are raising are the facts that have been pleaded by the Assembly. And that preliminary issue, when determined, may as well as dispose of the suit, and it is for that reason that we raise it as a preliminary issue, because if this Honorable House was to find that there was no sitting of the Assembly, then we cannot proceed with the hearing of the impeachment motion. And so we submit that these questions that we have raised satisfy this threshold, and we invite the Senate to look at the facts that have been pleaded by the Assembly and the documents that have been provided, and agree with us that this is a case of a phantom impeachment. Finally, as I, with one eye on the clock, we submit that this process is a hallowed process. It is not just about whether the grounds set out in Article 181 of the Constitution have been met. If the Senate is to examine whether there was a valid resolution and agree with us that the documents that have been presented are forged and cooked, then this impeachment, this phantom impeachment, amounts to an affront on the Constitution, and it sets a very dangerous precedent, because what it means is that it is possible for the Speaker and a few members of a rogue assembly to, in a way, attempt a coup, sit somewhere, cook documents, and present it to the Senate, and the Senate will then hear that matter. That in itself will be a violation of the Constitution, because this Senate has a mandate to protect devolution and to protect the counties. And that is the danger that we face in these phantom impeachment proceedings. Honorable Senators, the impeachment proceedings not only put the governor on trial, it does the same for the Constitution. It does the same for the Senate, for the members of the county assembly, for the witnesses, for the lawyers on either side, and ultimately the Kenyan people. It is our humble submission that the Kenyan people vested the power of impeachment in the Senate because they expected that the senators had special qualities, numbers, and temperament to rise to the occasion, and we urge this House to rise to that occasion. Finally, before I cede ground to my fellow counsel, allow me, Honorable Speaker and Honorable Senators, to just remind you of the words of Alexander Hamilton, one of the founders of the American Constitution, on the power and the question of impeachment. Hamilton explained that the senators were seen as the ideal arbiters in an impeachment process because the Senate would be a tribunal sufficiently dignified and sufficiently independent of the actual interest aligned in the subject of an impeachment. We urge this House to rise to this occasion, and we respectfully urge the Senate to review the material that we have provided and to find that there was no sitting of the Assembly that gave rise to the resolution that is before you for consideration. And Honorable Speaker and the Honorable Senators, I thank you for the opportunity you have accorded us to address you on this issue, and I invite my senior Elisha Ongoya to take us on the second limb of our preliminary issue.
Thank you so much, Mr. Speaker, and thank you, distinguished senators. As indicated, my name is Elisha Ongoya, lead counsel for the governor. Before I address you on another substantive preliminary question on an existing court order touching on these matters, allow me to invite my learned colleague, Mr. Elias Mutuma, to wind up on that issue of the proceedings before the Assembly by drawing your attention to certain salient material aspects of the purported Hansards that have been presented before you, so that you have all that in consideration. Then I'll move to the next subject. Thank you so much, Mr. Speaker.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The council representing the County Assembly will be here shortly to try and convince you that what we have raised is not a preliminary objection, but requires an interrogation by way of listening to witnesses and making a determination based on what they will say. But our submission is simple, honorable senators, that what we have raised is a pure PO that can be addressed and determined based on what has been presented by the County Assembly of Isiolo. Honorable senators, my understanding of Hansard's records is that they are a verbatim record of what transpires in a House proceedings. Therefore, they are able to tell us exactly what happened on the day that that motion is said to have been passed. We have raised an issue with proceedings that are said to have taken place on the 18th of June 2025 and proceedings that are said to have taken place on 26th of June 2025. Honorable senators, with your kind permission, kindly hold your volume 3 of the County Assembly's documents. I will take a very short time to take you through the Hansards, and this being a house that is also a house that is very much familiar with proceedings in the House, you'll be able to tell me whether there is anything that took place there. At page 7 of that bundle, we have been presented with what is said to be the proceedings of 18th of June 2025. Page 7 of 7, Saba 7 of volume 3 of the documents. Page 7. We see the House purportedly sitting for the first time. There is no communication from the chair. There is no calling of orders by the clerk. Straight away, the mover of the motion proceeds to execute the business of the day. Look at it. It is straight away withdrawal of the motion on the impeachment of Isiolo County Government dated 10th June 2025. What does it begin with? Honorable Abubakar Godana. Honorable senators, who presided over this session? There is no invitation from the Speaker for the mover of the motion to proceed and execute the business of the day. Let's proceed. Honorable Abubakar Godana proceeds and proposes a motion to withdraw the previous motion and invites two members of the County Assembly, Honorable Nicholas Lorot and David Nyoro, to second the motion. Without again the intervention of the Speaker, these two members rise and they proceed to second the motion. So who invites them to the floor? Who is presiding over this House? Let's go on. The two members support the withdrawal of the motion, and the Speaker now is seen for the very first time There is no question put to the members. There is no vote that has taken place. But the Speaker proceeds to say, the members, the notice of the special motion or the removal from office by impeachment, the Governor of Isiolo County issued on Tuesday, 10th June 2025, has been officially moved as requested by the mover, Honorable Bakar, member for Sericho Ward. We now proceed to the next business. So who approved this withdrawal? Who approved this withdrawal? Where is the vote? Let's proceed. Honorable Senators, we proceed to the Hansard now of 26 when the governor is being purportedly impeached. That's at page 23 of the same document. There is a communication from the chair. The first order of business, you will come across the order paper at page 17, where we have a total of 8 orders of the day. 8. But when you go to page 23, we do not see the clerk calling out the orders. Just look at it. It is the Speaker directly proceeding to make a communication. Is that an anomaly, Honorable Senators? We are all familiar with the business of the day. But what intrigues me more, Honorable Senators, the first order of the day here is to lay on the table the purported public participation report, which is done by Honorable David Lemantile, allegedly. He prosecutes his motion and argues on the public participation. Let's go to the end at page 31. But before that one, let's go slightly at page 30, where he completes his submissions. After laying the paper, public participation, we now see Honorable Peter Losu standing up to second this motion. Who has invited him to second this motion? Out of nowhere, he's not invited by anyone, but Hansards show that he rose to second this motion. And then the Speaker proposes the question and it opens the floor to the members of the House. At page 31, the last member seen to be speaking is Honorable Francis Letimalo. The Speaker now puts the question. So what happens after the question was put, Honorable Senators? There is no record whatsoever of what transpired. Nothing. A question is put, there is no indication that the House actually endorsed the public participation report. That Hansard is left hanging. Honorable Senators, after that paper is laid, the Speaker does not even call for the next order. The clerk is not seen anywhere calling for the next order. Instead, what do we see? Honorable Abubakar Godana is seen now on the floor. Hansards are supposed to be capturing verbatim what transpired. So who was in charge of this House? Where is the Speaker's recording inviting the mover of the motion to move the motion? Where is the recording of the clerk inviting, or rather calling for the order, for the next order? There is nothing. Instead, we just see someone on the floor prosecuting the motion. And he proceeds and proceeds. At page 35, he's done. Strangely, the first paragraph at the top of page 35, when he completes to execute his motion, he does not invite anyone to even second. Records are there. But we see one Honorable Major Golicha now standing up to second the impeachment motion. Who has invited him? There is no one. And other members, strangely now, so the House is suddenly in an autopilot. So from Honorable Major, then we see the Speaker opening the floor. You have Honorable Peter Losu. He continues. Without the intervention of the Speaker, there is another member, Honorable Salesio Kiambi, who proceeds as if the Speaker is not in this House, as if the clerk is not in this House, and proceeds. Another member just rises up from nowhere. There is no recording of the Speaker inviting any member to make a contribution to this motion. Apart from, of course, page 39, when suddenly the person cooking this answer realizes the Speaker has not been captured in this, and now we see the Speaker for the first time. In conclusion, because I do not want to take time that my senior is going to take to address you on the other issue, look at page 41. After the members purportedly complete to make their submissions, the Speaker makes very strange remarks, and I quote at page 41. Clerk, is the Governor or his legal representative available? Sergeant at Arm, can you check around if the Governor or his legal representative are present? The Speaker does not even take time to communicate to the House whether the Governor had been invited. He does not even read that invitation notice as required. So why is he calling for the Governor, whom Learned Counsel had told you was invited to appear at 9 and we at 2 o'clock? The Speaker is not seen anywhere saying that we invited the Governor by this letter and he has not come, but instead asked the clerk to check whether the Governor is available anywhere. Let's proceed. I'm completing, Honorable Senators, and this is going to shock you. So, when the Governor was confirmed was not in the House, the Speaker proceeds to guide the House on the next move. At the end of that page 41, I read what the Speaker says. When the doors, I'm reading the last part, when the doors have been locked and the bar drawn and the names of the tellers have been announced, the Speaker shall, this is the Speaker telling them, the Speaker shall put the question again in the presence of the tellers. When called out, each member shall thereupon rise in his or her place and declare assent or dissent to the question in the following manner. I vote yes or I vote nay. Proceeds. Honorable Senators, page 42. Where does the Speaker put that question to the members of the House present? There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place on 26th and 18th. I rest my case.
Thank you, Mr. Speaker, and thank you, distinguished senators. I'll proceed to argue the final limb of the objection, but just to cap up what my learned colleagues have told you, that if before you is a purported Hansard in the form and content that you have been taken through, if before you is a purported Hansard that no one has taken the courage of his or her conviction to certify, if somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell. Is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? And if we conclude, as I invite you to, that what is before you is a mere piece of paper, to the extent that it is not certified, can we take any other proceedings on the strength of that mere piece of paper? That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are 2 subtitles at page 60 of that manual, which is subtitle 1, Comply with Court Orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is Participate Actively in Court Proceedings, and this Senate has communicated to us through this manual that ignoring court orders against the county assembly or the Senate is not the solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist. Because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly, before the new Constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the governor's documents. It is found in volume number 4 of the governor's documents, and you'll find that ruling starting at page 165 of volume number 4 of the governor's documents. But the relevant part I would refer to in the interest of time is at page 168 of that volume, volume number 4 of the governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I will then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the third paragraph. Although I have read that this court decision does not stop the National Assembly from proceeding with its work and cannot determine for the House how to proceed, it must be noted, as matters currently stand, any decision made by this House on the nomination, though perfectly procedural from the point of view of the legislature, outside the legislature, it is, to the extent that it does not accord with the ruling of the court, null and void for all purposes. So that is the guidance that Honorable Marende makes. Allow me to then come to the specific ruling that we wish to draw this Senate's attention to, and that I will refer you to volume number 4 still. Thank you so much, Mr. Speaker. And as somebody who has been here multiple times, I'm always impressed by the support we get from the administrative teams in this Senate that may have to go on record in the interest of posterity. At page 13 of volume number 4 is a decision of the court in Isiolo High Court Constitutional Petition number A004 of 2025. The parties are Honorable Abdi Ibrahim Hassan, the governor now before you as petitioner, and the County Assembly of Isiolo before you as the first respondent. There are two other parties in that matter, but safe to highlight that the parties before you are parties in that suit. They are therefore bound by the decision of that court. At page number 25 Allow me to just go straight, Mr. Speaker, to page number 27. You'll find a paragraph 28 of that ruling. And the judge observes as follows: it is important to note that there was no complaint raised when the first orders were issued by the court in respect of the motion dated 10th June 2025 that was to be debated on 17th June 2025. In fact, the sentiments by the mover of that motion, the contemnor, actually vindicate the court, as he has in his affidavit conceded that the motion was defective in substance and marred with procedural irregularities, the very grounds that the petitioner has sought to rely on. The mover of this motion went to court and told the court, it is true that the orders you gave first were right, because the motion I had tabled was marred. It was defective in substance and marred with procedural irregularities. The move of the motion. Allow me to then take you to paragraphs 45, 46, and 47 of that ruling at page number 35 of volume number 4. Paragraph 45, the judge says, therefore, it is the finding of this court that the motion dated 18th June 2025 and debated by the first respondent on 26th June 2025 was in contravention of the conservatory orders of this court issued on 25th June 2025. Hence, the resolution arising therefrom is null and void. Once an act is declared null and void, it is of no legal consequence. A court of law has found that this motion, which has now been brought here before you, senators, is null and void. It is of no legal consequence. Paragraph 46. As stated, the resolution has evidently been submitted to the Speaker of the Senate. It is thus upon the Senate, once informed of the orders herein, which I'm now doing, Mr. Speaker, distinguished senators, to determine if it will proceed to handle the said resolution, thus abating a blatant disregard of the rule of law or the respect of orders. The matter at hand calls for a stand to be taken by the constitutional organs involved. What they choose to do will have set a precedent on the necessity for compliance with court orders. It is a choice between anarchy and constitutionalism. Distinguished senators, the judge is saying this. The judge is saying, I am aware. I cannot stop you from doing your work. So he's saying, proceed and go to Senate. And that, to my mind, was an extremely wise move by the judge, considering historical pleas for there to be institutional committee between institutions and to respect the powers of each organ. But the judge is saying, so you decide for yourselves how you will proceed. I have made a finding that that motion is null and void and of no effect. I want to contradistinguish this with other scenarios that the other side will draw your attention to shortly. The judge has not issued a conservatory order against this Senate. The judge has made a determination on the validity of the motion purportedly debated and purportedly approved by the County Assembly of Isiolo. The judge has made a determination. It is null and void and of no legal consequence. You are being invited to engage with this motion on that strength of fact, on the strength of the finding by the judge that the motion as approved, as brought before you, is null and void and of no legal effect. We therefore invite you to introspect and make this determination. When the impeachment law calls upon you to determine a motion that has been approved by the County Assembly, is it just any motion or a valid motion. If there is information before you that the motion is invalid for any reason, what is the precedent that has been set by this Senate? It is against that background that I wish to draw this Senate's attention to its resolution that is found from pages 136 of volume 4 of the governor's documents. And this was the determination of the proposed removal from office by impeachment of the governor of Kericho County, Honorable Dr. Eric Kipkoech Mutai. On that occasion, the validity of the resolution was questioned on the ground that the motion had not met the threshold. And rightly, this House found that it could not move a step further because validity of the motion is an important precondition to the carrying out of the trial process on the motion. Similarly, by parity of reasoning, today, validity of another motion has been impugned on two grounds. One, there was no sitting known to law of the County Assembly of Isiolo to approve the motion. And number two, in any event, a court of competent jurisdiction has made a finding that whatever came from the County Assembly of Isiolo is null and void and of no legal consequences. Will you, in the face of the precedents you have set by previous speakers' rulings and by resolution in the case of Kericho County Governor's case, proceed to trial on that understanding? We beseech you with humility to find that there is no motion known to law before you and thereby to down your tools. I humbly submit and respect and rest the governor's submissions on that question of the preliminary objections. I reserve our 10 minutes, Mr. Speaker, for a rebuttal from this side once the County Assembly has finished their response. Thank you so much, Mr. Speaker. Thank you, Senators.
Counsel for the County Assembly.
Mr. Speaker, I will respond to the arguments that have been made by my learned colleagues for the governor, and I am the only member of the team for the Assembly that will respond to those preliminary issues. Mr. Speaker, I am grateful for the opportunity to respond to those preliminary issues. I shall constrain myself to the time that Mr. Speaker has gladly extended our way. Mr. Speaker, I wish to start my response to those preliminary issues by stating that a preliminary issue, by definition, must be an issue that goes to the ability of this House to entertain the motion before it. It cannot be an issue that is merely important to the governor. It cannot be an issue that is merely important to the governor. Sorry, I cannot see my time. Thank you very much. It cannot be an issue that is merely important to the governor, and the governor then chooses to bring it forward and deal with it as a preliminary issue, and it does not go to the ability of this House to hear the motion before it. And, Mr. Speaker, it is settled that a preliminary issue assumes that the facts are settled. Mr. Speaker, the consideration of what the Governor's Council purports to be a preliminary issue involves the detailed consideration of evidence. I was constrained to stand up on my feet and object whilst my learned colleagues were on their feet, because it was apparent that what my learned colleagues were doing for the Governor was leading evidence. They were testifying. They were referring to contested statements in the bundles of both documents, And there are responses from the County Assembly in respect of those statements. And those statements must be tested by way of cross-examination. And only once the evidence is laid before this House and it is tested, like the Assembly is entitled to do, then can this House make up their minds as to whether or not those issues hold any water. I am not saying that this House should not consider those issues. But what I am saying emphatically is that this House should not consider those issues as issues that are preliminary to the determination of the motion. There are issues in the motion, and I will demonstrate in a moment how those issues are indeed issues in the motion. I will choose, or I have chosen to respond to the issues that were argued by my learned colleagues for the governor, using a slightly different framework from what they did. We distilled 3 or 4 issues from the notice of preliminary objection that was served on the Assembly, and I wish to crystallize the first issue I wish to respond to as follows, Mr. Speaker. That the governor challenges the validity of the impeachment motion in light of the declaration by the High Court of Kenya sitting in Meru that the impeachment proceedings are a nullity. It is correct, as was submitted by Mr. Ongoya, that it is not contested that indeed there are orders that were issued by the High Court of Kenya sitting in Meru in respect of these proceedings. But what is contested, and I doubt we will agree on this, is the effect of those orders on these proceedings. Mr. Ongoya and his colleagues say that the effect of those orders on these proceedings is to invalidate them, and this Senate should therefore down its tools. We disagree. I submit, and I wish to submit, Mr. Speaker, and emphasize that elections to offices, such as those occupied by the members of this House, are conducted by the people of Kenya in furtherance of primordial sovereignty. Mr. Speaker, the exercise of removal of an elected official, such as the removal of a governor, is therefore, in my submission, the flip side of that exercise of primordial sovereignty. And as authority to my submission, I wish to refer, Mr. Speaker and members of this House, to the provisions of Article 1 of the Constitution. Mr. Speaker, Article 1 of the Constitution provides as follows at Article 1:1. It states that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. That is an affirmation of sovereignty by the people of Kenya, and it is clear where the sovereignty lies. Article 1:2 then goes on to say that the people may exercise the sovereign power either directly or through their democratically elected representatives. The important provision of Article 1, which I wish to emphasize, is the next provision. Mr. Speaker, sovereign power under this Constitution is delegated to the following state organs, which shall perform their functions in accordance with this Constitution: Parliament and the legislative assemblies Parliament and the legislative assemblies in county governments, the national executive and the executive structures in county governments, the judiciary and independent tribunals. Mr. Speaker, the function of the removal of the governor is delegated to the Senate of the Republic of Kenya by virtue of Article 1:3. The election of the members of Parliament, members of the National Assembly, members of the National Assembly, members of this Senate, and any elected office is done directly by the people of Kenya. Mr. Speaker, as I have said, impeachment is the flip side of election, and it is done again here by the people's representatives. And here I wish to emphasize this point. Mr. Speaker gave a correct and appropriate direction at the beginning of these proceedings, that voting on this motion is by delegation. Voting on this motion is not by all members of the Senate, but it is by delegation. And I submit that that is in recognition of the special role, the special function that this House is being called upon to perform when you sit to consider the motion for impeachment. It is not legislative, but it is delegated, and the House has correctly interpreted that role as being exercisable only by delegations and not by all members. Mr. Speaker, it is my submission that a correct interpretation of the doctrine of separation of powers is as follows. Mr. Speaker, and it has been held not just by this House and not just by the High Court, the Court of Appeal, and the Supreme Court, that the role of the judiciary in examining impeachment proceedings arises or kicks in once the impeachment proceeding is complete. Yes, the judiciary has a role, but the judiciary then, as has been correctly held, does not have the ability to intervene at every stage. In our written submissions, Mr. Speaker, we have referred you to the relevant decisions of the Court of Appeal. We have referred you to the decision of the Court of Appeal in Kawira Mwangaza and the decision of the Supreme Court rendered earlier in the matter of Martin Nyaga Wambora. And I wish to suggest a reasoning, perhaps, why the law is as it is. Impeachment proceedings and many proceedings under our Constitution are time-bound. And if judicial intervention is allowed in some of these time-bound proceedings as they proceed, it is not clear whether the judiciary has the ability to suspend constitutional time so as to allow the judicial proceedings to proceed, or whether it is better off to allow the impeachment proceeding to proceed and be completed, and then what is taken is a process review of a completed proceeding to court. What am I saying? The correct interpretation of the doctrine of separation of powers, and it has been held repeatedly by this court, by this Senate, and by the courts, is that even where an impeaching assembly is making a mistake, allow it to complete the mistake. And what is then justiciable is the completed mistake. Don't interfere in between because of timelines, and that, I submit, is a modern interpretation of the view of the doctrine of separation of powers as to how it applies to the power of legislative assemblies, county assemblies, and this House to carry out their function of impeachment. Mr. Speaker, there was reference to a decision that was made by Kenneth Marende when he was Speaker. And it was a decision in respect to the appointment of the Honorable the Chief Justice of this Republic. And I wish to distinguish that decision from the matter that is before you for this important reason. Mr. Speaker, I have stated, and I will take your permission to emphasize, that impeachment are time-bound proceedings. The appointment of the Honorable the Chief Justice, yes, was a constitutional process, but it had no time limit. And the process of that appointment had the luxury of time. It could take as long as it needed to take, and it then made room in it for judicial interventions during the process of the appointment of the Honorable the Chief Justice. I have stated, and I will emphasize, that impeachment proceedings are time-bound proceedings. And if they are not concluded in time, we would then be faced with the ridiculous situation where somebody runs to court and say that Assembly X or the Senate of the Republic of Kenya did not complete their mandate in time. And I believe I was seated here a few months ago when the impeachment proceedings of the Deputy President of the Republic of Kenya were being conducted. And that was an important consideration, the strict timeline that guided many of the directions that, Mr. Speaker, you made during those proceedings. I urge you to call on that wisdom and to find, if you are persuaded to consider this as a preliminary issue, that because of the strict nature of the timelines, then the room for court or the role for court is ex post facto considerations of completed processes of impeachment. Mr. Speaker, there is a decision that has been referred to, and it is a decision that we advocates all know, and I'm glad, Mr. Speaker, you are an advocate, and I'm sure you are familiar with this decision. It is a decision that is referred to in the submissions by the governor. And that is the decision of Lord Denning in the famous case of McFoy versus United Africa Company, where they seek to persuade, and in citing that decision, counsel for the governor seek to persuade you that because the proceedings are a nullity, then you should not proceed any further with these impeachment proceedings. I wish to rely on that decision, Mr. Speaker, and I wish to rely on that decision in an attempt to persuade you that it is indeed the proceedings before the High Court of Kenya in Meru that were a nullity. Coming as they did, contrary to the established law and contrary to the established interpretation of the modern doctrine of separation of powers, prior to the completion of the impeachment proceedings, those or that decision or references to that decision are a nullity, and you should disregard that decision and proceed. Mr. Speaker, I had a few passages from the decision, and learned counsel for the governor seemed to be suggesting that the judge of the High Court in some way may have been directing this House as to what to do with its orders. I submit that this House is completely independent under the Constitution of the Republic of Kenya, and you should be guided properly as you then consider this preliminary issue. But in conclusion, I wish to state that this preliminary issue is not a preliminary issue. It is based on contested issues of fact, which we should then get the opportunity to look into. The second issue that I wish to respond to is an issue that when I first encountered it, I was a little concerned. And that is the submission that has been made by my learned colleagues for the governor, and they have taken some time on it, that there were no sittings of the County Assembly of Isiolo on the 18th and the 26th of June 2025. They have used that submission in support of several grounds of their PO, and I wish to respond to that ground. And I wish to ask the House to apply it to all instances where they have made reference to the fact that indeed there were no sittings on the 18th and the 26th of June 2025. I wish to submit that that argument, with tremendous respect to the governor and his team, is self-defeating. And it is a self-defeating argument if you look at it from this perspective. Mr. Speaker, it is the proceedings of the County Assembly of Isiolo of the 18th and the 26th of June 2025 that the governor has taken to the High Court in Meru, and it has resulted in the decision of Mr. Justice Nyaga sitting in the High Court in Meru, which is set out, the order arising from Mr. Justice's decision is on, Mr. Justice Nyaga's decision, is on page 6 and 7 of volume 3 of the governor's document. And the ruling itself is to be found between pages 13 and pages 37 of volume 4. And having based substantive legal proceedings on the proceedings of the County Assembly of the 18th and the 26th of June 2025, it then cannot fall from the governor's mouth to come here before you this morning and assert that there were no proceedings. They have based substantive legal proceedings on the fact that there were proceedings. They have gotten certain orders from the High Court in Meru, which orders they seek to bring before you and urge you to declare the proceedings a nullity. I submit that they cannot. And for the completeness of the record, I submit that an estoppel arises against them approbating and reprobating in the manner in which they do. And an estoppel, for the purposes of my submission, is a legal principle which precludes a person from asserting something contrary to their previous action or statement. The contrary provision is that there were no proceedings. The previous action is that they took those proceedings to the High Court, persuaded the judge of the High Court that there were proceedings, and obtained orders. They cannot do both. And for that reason, I urge you, I submit that that ground of the PO must fail. there is the issue that my good and learned friend, Mr. Theory, commenced with. And I wish to crystallize that issue as the threshold issue. The short and sharp answer to the threshold issue is that threshold, the determination of whether or not a motion surpasses the threshold required in law requires the consideration of testimony of evidence from both sides. And the consideration of evidence must of necessity, Mr. Speaker, include the testing of that evidence. There are witnesses that the governor has brought, and there are witnesses that the governor has brought and their testimony was referred to in support of this submission. We, as the advocates who are present for the county assembly, wish to test that testimony. We do not believe that what has been stated in those statements is correct. Those facts, Mr. Speaker, are therefore contested. And if they are contested facts, they then cannot form the basis in law or otherwise for a preliminary issue. That must go on to full trial, and in the context of these proceedings, that means the hearing of the motion that has been brought. Mr. Speaker, one of the reasons that the governor gave for in support of the submission that the threshold has not been surpassed was the fact that the minutes in support of those, the Hansard, sorry, not the minutes, Mr. Speaker, in support of those two proceedings were not signed. Mr. Speaker, we note that one of the governor's witnesses is the clerk of the assembly, the county assembly of Isiolo. Most unusual in the circumstances, because it is the clerk's responsibility to sign those Hansard proceedings. We look forward to the opportunity, Mr. Speaker, to test the testimony of the clerk and get the clerk's explanation. And we believe this House can only benefit from that explanation from the clerk, who is charged with the primary responsibility of certifying those minutes, as to his explanation as to why those minutes were not certified. The clerk is a witness. He has put in a witness statement or an affidavit, and we wish to test his testimony. Mr. Speaker, it is my submission that with the facts contested as they are, it is then difficult to use those facts to then make a determination on the preliminary issue. The next issue that I wish to submit on and emphasize is that the material that the governor wishes to rely on for his preliminary issue is the same material that the governor has brought forward or seeks to rely on as testimony in opposition to this motion. Mr. Speaker, members of the House, I wish to refer you now to Volume 2 of the governor's response to the motion that is before you. And in Volume 2, there is the statement at page 24, and this statement runs all the way to page 32 of one Salad Buro Guracha. Salad Buro Guracha is the clerk of the County Assembly of Isiolo. As I have said, in a most unusual way, he is a witness for the governor. He makes certain averments in that affidavit, which we need to test. Those averments have been repeated by other witnesses, and it is those averments that have been relied on by my learned colleagues on the other side in support of their assertion that there is indeed a preliminary issue that requires consideration and needs to be determined as a preliminary issue. Mr. Speaker, I wish to cede the remainder of our time to my colleague, Mr. Mawira. But as I take my seat, Mr. Speaker, I wish to make the following suggestion. Mr. Speaker, it is apparent in a rather blatant manner that the issues that have been brought as preliminary issues before you are not preliminary issues, whereas they may be issues that are fit and proper for the determination of this House, but they are not fit and proper for determination as POs. My suggestion, Mr. Speaker, is that the PO be dismissed and that the governor has an opportunity then to ventilate those issues in his evidence in opposition to the motion, and that this House then makes a determination on those issues once it has had the benefit of hearing testimony from both sides, and both sides have had an opportunity to test that testimony. How much of that?
Honorable Speaker, my name is Manuel Confis Mavera. I'll take the remaining time to address the submissions that have been made by my learned senior. Foremost, Honorable Speaker and members of this House, it is not contested that there is no order, there is no conservatory order stopping Senate from considering the impeachment motion that is before you. There is no order by court injuncting or enjoining this House not to proceed with the business of the day. What the governor challenges or impugns is the validity or otherwise of the impeachment motion that is before you. I submit, Honorable Speaker, that the question of validity of the impeachment motion is a question of interpretation that is reserved for the judicial arm or branch of government at the opportune time. As my learned senior, Nyamoji, has already submitted, we have authorities in the submission that we filed in response, and this Honorable House has given rulings in previous matters, including the previous ruling in the impeachment, in the matter of the impeachment of the governor of Kericho County, that legislative processes that are before Parliament, the moment this House or Parliament is seized with a resolution by a county assembly to remove the governor from office, this House becomes irreversibly seized of that impeachment motion, and no order of court can stop this Honorable House from conducting its business. More importantly, Honorable Speaker, that position has been adopted not only by this Senate or this Parliament, but by other parliaments world over. We have authority in the report of the committee on the proposed removal from office of the governor of Embu County that the Senate becomes irreversibly seized of the matter the moment the Speaker of the Senate receives a letter from the Speaker of the County Assembly communicating the resolution of the Assembly to remove the governor from office. The committee went ahead, Honorable Speaker, to quote similar positions adopted by parliaments in other jurisdictions, including Ghana, in the Supreme Court of the decision there, Honorable Speaker, Sri Lanka, and the United States. Honorable Speaker, the position that has been taken by this House in previous impeachment proceedings has been adopted by the highest courts in the Republic. The Supreme Court in the matter of the governor of the former governor of Embu County, Martin Ndega Wambora, and the Court of Appeal have agreed with this House, Honorable Speaker, that the judicial arm of the state cannot direct Parliament on what to do and not what to do. Therefore, it follows, Honorable Speaker, that at the opportune time when this Honorable House has conducted its proceedings, these proceedings will then fall
before the judicial arm of the state. And at that time, the judicial arm of the state will have every opportunity to test the proceedings of this House for constitutional compliance. It is agreeable, it is common ground, Honorable Speaker, that the proper judge of compliance with the Constitution and the standing orders of this House and the statutes relating to the removal proceedings of the governor is the judiciary. The question or the point that is not agreeable by both sides is at what point can the courts stop an inchoate or an ongoing constitutional process that is before the legislative assemblies. The Supreme Court, Honorable Speaker, in the matter of Matanyaga Wambora, had occasion to deliberate on this issue. And at pages 6 of our submissions, page 6 and 7, Honorable Speaker, you will find an exposition of what the Supreme Court said. The Supreme Court explicitly forbade, Honorable Speaker, courts from granting orders that stop ongoing proceedings that are before legislative assemblies. And to quote what the court said at page 6, in fact, it is at page 7, Honorable Speaker, no governmental agency should encumber another to stall the constitutional motions of the other. The best practices from the comparative lesson signal that the judicial organ must practice the greatest care in determining the merits of each case. So, the question that arises, therefore, Honorable Speaker, is while the governor impugns or challenges the validity of the impeachment motion, the validity of the court order that was given, which court order is a basis of the challenge that the governor has put up to the propriety of these proceedings, is also in question. The validity of that court order is in question because, Your Lordship, because, Honorable Speaker, the highest court in the Republic have affirmed what this House has stated on numerous occasions, that the judicial arm of the state, though it can intervene to stop or to check for constitutional compliance, that process before the Legislative Assembly should be left to run its full course, and at the opportune time, the judicial arm of the state can intervene to check the propriety of those proceedings. Therefore, Honorable Speaker, can a court, the High Court, and Honorable Speaker, Section 5 of the Judicature Act provides for the hierarchy of laws in our republic. The Constitution is at the top. Honorable Speaker, the apex court in the republic, as per our Constitution, is the Supreme Court. The Court of Appeal is next. The decisions of the Supreme Court, as per Article 163(5) of the Constitution, Honorable Speaker, are binding on the High Court. The same goes for the decisions from the Court of Appeal. The question, therefore, is, can this Honorable House be stopped by a court that has disregarded binding precedent? Can this court be stopped by a court that itself is lacking in jurisdiction? Our response or our answer to that question, Honorable Speaker, is that you should proceed unhindered, undeterred, and render a decision or a determination on the impeachment motion on the merits upon hearing the witnesses that are to be called by the respective parties. The danger, Honorable Speaker, is if this Honorable House was to terminate the proceedings at this stage, then, Your Lord, Honorable Speaker, it would set a very dangerous precedent. And that dangerous precedent, Honorable Speaker, is that all that a governor would need to do is to move to court and obtain an order either quashing the impeachment proceedings before they even begin, or stopping this House from considering the impeachment motion before it is even seized with that impeachment motion. And therefore, Senate would have abdicated its role as a defender of devolution. Senate would have abdicated its oversight mechanism in the removal from office proceedings of county governors. And therefore, Honorable Speaker and the members, as you deliberate on that issue, we sound that caution that whatever is established today will have an implication on future impeachment processes that will be brought before this House. On the second ground of the PU, Honorable Speaker, counsel for the governor have referred to affidavits by the clerk of the assembly and affidavits by the AP commander, Isiolo County. And all these affidavits, Honorable Speaker, have been referred to persuade you that there was no sitting by the assembly on the 26th of June 2025 when the impeachment motion was approved by the county assembly. The question that arises, Honorable Speaker, is whether the contents of those affidavits can established, whether the contents of those affidavits are to be believed without testing the evidence of those witnesses under oath. So, the way I see it, Honorable Speaker, is that the governor is asking for a full trial. By making a reference to those affidavits, it must be taken that the governor concedes that that PO is not a pure point of law, is not based on a pure point of law that can be canvassed by counsel without reference to affidavits by witnesses. The reason we file affidavits before you, Honorable Speaker, is to give advance notice to the other party, so that the other party can prepare on how to test the truthfulness, the credibility, and the veracity of those witnesses when they take the stand to give evidence before this House. So, Honorable Speaker, the contents of those affidavits, the depositions that are contained in those affidavits would have to be tested by way of cross-examination of the witnesses for this Honorable House to make a conclusion on that question as to whether there was a sitting. The same goes for the answer that is impugned by the clerk of the county assembly on oath. With regard to the question of further on that question of the alleged forgery of the answer, all the counsel for the governor has done is to make reference to an affidavit by a witness. Counsel was submitting on what is supposed to be a preliminary point of law. It is no longer a preliminary point of law, Honorable Speaker, if counsel does not restrict himself and now, takes the posture of the witness and testifies on behalf of a witness on what they have deponed under oath in an affidavit. At the opportune time, Honorable Speaker, we will be praying to cross-examine those witnesses in order to establish the truth. The further question that arises, Honorable Speaker, as I conclude, is the clerk of the assembly under the County Assembly Services Act is required to render expert non-partisan advice to the Speaker and to the House on procedural matters and all other matters that are before the House. We will be craving for an opportunity to cross-examine the clerk on all the issues that counsel has alluded to in trying to persuade you, Honorable Speaker, and the House that you dispose of the issue of whether there was a sitting and the issue whether there was forgery of the answer at this preliminary trial. A mini trial that the governor requests for, a trial within a trial, is not necessary, Honorable Speaker, if the issues that are to be canvassed during that mini trial can be established in the full trial. or that the issues of the sitting of the Assembly, the issues of the alleged fraud, the alleged forgery, are matters that belong to the full trial. It is for the governor to prove that indeed there was forgery, because he's the one who alleges there was forgery of the answered report and that there was no sitting. It is for the governor to prove through evidence that is going to be tested by way of cross-examination at the trial. Therefore, Honorable Speaker, reducing that issue, and it's a very germane issue, the issue of the sitting and the alleged forgery, to a matter that can be handled at this stage without leading evidence is not only inappropriate, but against the best interest of justice, because the County Assembly will not have the opportunity to cross-examine the witnesses that are being called, and those affidavits have been referenced to by the Governor's Council in making that preliminary point. In conclusion, Honorable Speaker, it is only after a lengthy and a drawn-out hearing in the main trial that all these issues that are couched as preliminary objections can be sufficiently addressed. Honorable Speaker, I'll say one last thing on that issue of the court order before I cede a few minutes to my colleague, Mr. Muriuki. Honorable Speaker, the issue of the court order that is the governor has alluded to is not to be looked at just as a standalone issue, or as it is essentially, Honorable Speaker, an attack on the jurisdiction of this Honorable House to hear the impeachment motion that this House is seized of. The question, as I said before, is if a court whose jurisdiction is challenged, because in fact, Honorable Speaker, I was in those proceedings and the jurisdiction of the court was challenged. The court has not rendered a decision on a preliminary objection that was filed, but the court proceeded to grant the orders that were granted. Can a court whose jurisdiction is challenged and which court, the apex court in the Republic, together with the Court of Appeal, have held that our court is bereft of jurisdiction, take away the jurisdiction of this House, which is constitutional in nature, the jurisdiction of this House to oversight county assemblies is constitutional in nature. Can a court acting in excess of jurisdiction take away the constitutional mandate of this House? As Mr. Nyamodi quoted just before he took the stand, Honorable Speaker, the decision in Mark 4 on the validity of that court order comes into play. Because, Honorable Speaker, there is no need for that court order to be set aside. The moment that court order was given by a court that has disregarded binding precedents from the Supreme Court, from the Court of Appeal, and acted in excess of jurisdiction, that order is a nullity in law. So much as the court order says that the proceedings before the Assembly were a nullity in law, the court order itself is a nullity in law. There is no further order of court that is required to set aside that order, because that order itself is a nullity in law. It cannot stand. Therefore, Honorable Speaker and the Senators, I urge you, as I conclude, not to cede to the request, not to accede to the request by the Governor's lawyers to take away the jurisdiction of this Honorable House on this important question that is before you for determination. I will cede the remaining minutes to my colleague, Mr. Muriuki.
Honorable Speaker, esteemed members of this House, my name is Eric Muriuki. I am privileged to appear before you once again. I represent the County Assembly of Isiolo. Honorable Speaker, esteemed members, to continue with our submissions where my colleague has left off, the question that should seize this House, and Honorable Speaker, when you go to make your determination, is this: on a balance of conveniences, what ought to happen? We submit that this House ought to proceed with these proceedings because, as has been held in numerous court decisions, the governor will have the opportunity to challenge these proceedings in court. However, neither the court nor this House can freeze the statutory and constitutional timelines that are set for impeachment proceedings. So, Honorable Speaker, allowing the PO in the way that the governor's team asks this House to do would irreparably prejudice the Assembly, because there is a chance for the governor to challenge these proceedings, but there is no chance for the Assembly to reinstate or to pause this process and then come back. The proper time to question the validity of impeachment proceedings, as has been ably submitted by my senior Nyamodi, is after the process is complete. And Honorable Speaker and members, this is what the court held in the case of Kawira Mwangaza versus the County Assembly of Meru. Honorable Speaker, this position was also buttressed or had earlier been held in the Justice Kariuki Mate matter. Honorable Speaker, allow me to read an excerpt from the decision of the Court of Appeal, that is Mwangaza versus County Assembly of Meru and another, 2023 KECA. We observe that the applicant's right to be heard and to defend herself from the allegations made against her in the impeachment debate at the County Assembly of Meru provided under the standing orders of the County Assembly. If she is impeached, and emphasis on this part, Honorable Speaker, she will have another opportunity to present her case before the Senate during the hearing of the impeachment motion. Further emphasis here, Honorable Speaker, even after the Senate makes its decision, the applicant still has the avenue of petitioning the court for an appropriate relief if the decisions were to go against her. We are therefore of the considered view that the applicant's right to be heard will not be circumscribed. Enough said, this court lacks jurisdiction to consider the application before it for the reasons stated in the ruling. That is the Court of Appeal, Honorable Senators speaking. The second question that this House and Mr. Speaker should ponder is, where is the public interest in this matter? In this matter of the PO. This is an important question. The impeachment process has commenced. The Supreme Court and the Court of Appeal have, in very clear and no uncertain terms, they have forbidden lower courts from granting the kind of orders that the governor has brought here today, saying that he wishes to rely on to scuttle these proceedings. And, Honorable Senators, even where such orders are issued, what does the Supreme Court say? It says that should those orders be issued in error, then the Assembly, the County Assembly, is entitled to not immediately comply with those orders. Honorable Speaker, these are not my words. These are the words of the Supreme Court itself in the Mati decision. Paragraph 95 of that decision, and it is found in page 8 of our submissions, where the Supreme Court says, it is our understanding that the exceptional circumstances of this case, with a complex scenario of justiciabilities from contrasted standpoints, would lend justification to the non-effectuation of contempt orders at the beginning, and consequently, we would accommodate the reality of their not having been immediate compliance as would otherwise be required. The Supreme Court is recognizing that sometimes court orders are issued in error, and where the effect of those orders is to encumber a House of Parliament, a legislative house, from performing its duties, the Supreme Court is accommodating the reality that those orders do not have to be immediately complied with. Your honorable senators, on this basis, we therefore submit that it is in the public interest that this House dismisses this PO and proceeds to hearing, bearing in mind what the Supreme Court has said, what the Court of Appeal has said. Honorable senators, another issue I want to touch on is the issue of forgery that has been alleged in the governor's preliminary objection. And the only submission I will add to what my colleagues have said on that issue.
Counsel for the County Assembly.
Yes.
Just take your seat. I've got a communication to make. Now, honorable senators, ladies and gentlemen, the time now is 1 p.m. And in terms of our program, we are set out in the order paper. We are set to adjourn at this time. I note, however, that the County Assembly still has 10 minutes of their time. I therefore wish to invoke Standing Order 34-2 and 2A of the standing orders, which permit the Speaker, for the convenience of the Senate, to direct later interruption of the business for a period of not more than 15 minutes. I therefore direct that the County Assembly may utilize its remaining 10 minutes so that the Senate shall adjourn at 1:10 p.m. or such earlier time as the County Assembly concludes its submissions. The Senate then will resume sitting at 2:30 p.m. when the Governor's Council will have its 10 minutes to respond before the Senate proceeds to make a determination on the preliminary objection. It is so directed. Council, you may proceed to utilize your 10 minutes.
Thank you, Mr. Speaker, sir. As I was submitting, honorable senators, is that my colleagues have indeed said, and I agree completely, that forgery must be specifically pleaded and proven. The mere word of the Governor's Council on this pulpit cannot be taken as evidence of forgery. Indeed, in a decision of the Court of Appeal, Jennifer Nyambura Kamau versus Humphrey Bakanandi, the court held that it is also a settled law that fraudulent conduct must be distinctly alleged and distinctly proved. It is not allowable to leave fraud to be inferred from the facts. An allegation of forgery is an issue of fraudulent conduct. Honorable senators, you have been told that it is a preliminary issue whether there was a sitting and whether from that sitting threshold for impeachment was reached. Honorable Senators, this issue can only be determined after a conclusive hearing of these proceedings. The Governor's Council has stated that they will rely on the affidavit of the clerk, who is an employee of the County Assembly, to tell you that there was no sitting. Honorable Senators, as a matter of fair hearing, we must then be allowed to test the veracity of those averments by the clerk under oath through cross-examination. And for that reason, Honorable Senators, this issue cannot form the basis of a PO. Honorable Senators, from the locus classicus on POs of Mukisa Biscuits, as was again affirmed in the decision that we have quoted in our submissions of Ali Hassan Joho and another versus Suleiman Said Shaban, for a PO to succeed, it must be a pure point of law which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. And I would perhaps just amend that to also include quasi-judicial discretion, because this House now sits as a quasi-judicial body. So, Honorable Senators, that issue of whether there was a sitting is at length canvassed in both the County Assembly's documents and the Governor's responses. And for that reason, it therefore cannot form part of a preliminary objection. We shall be, of course, adducing evidence to show that there were sittings of the Assembly on those 2 dates, even though there were attempts to scuttle those sittings. Honorable Senators, as I conclude my submissions, we shall lead evidence at the opportune time to show that there was vandalism at the offices of the County Assembly and that the said vandalism was orchestrated by the Governor or at his direction. That is the evidence that we shall bring here. We shall also lead evidence, Honorable Senators, to show that there has been a pattern of attempts to scuttle these impeachment proceedings right from the start, and these attempts were made by the Governor. We shall adduce evidence to show that the Governor took every possible step, whether legal or otherwise, to try and stop and scuttle these impeachment proceedings. For these reasons, Honorable Speaker and Honorable Members, we submit that it is necessary and this House ought to rule that that PO is untenable and that we proceed with hearing of the full case. My colleague will finalize our submissions. Thank you.
Honorable Speaker and members of the Senate, I'll just take a few minutes just to conclude our remarks on behalf of the County Assembly. Honorable Speaker, I would just like to highlight the two-faced approach to the contest raised by the Governor. On the one hand, the Governor is saying that there was no motion, no resolution passed that is capable of coming before the Senate.
Counsel, for the sake of the Hansard, kindly state your name.
Honorable Speaker, my name is Paulo.